See you tomorrow, Judge.
All right. Okay, Ms. Rivers, we are back on the record, please, in State versus Adams. And what I understand, Mr. Tevis, from your basic recitation of the facts, I know you're just basing this on police reports and whatnot, is that in about a year ago, a little less than a year ago, August, in South Fulton at some place called the Wing Depot, there was some suspected drug transaction that occurred, maybe even in the Wing Depot. And at some point, a guy named Julian Terry gets out of a Corolla, gets into your client's Explorer, and then the police are in business. And they come up to the Explorer. Your client is detained at least. They search the Explorer. They find a gun, 2 cell phones. You didn't say they found drugs. Find out where drugs were found, if any were found. And you are seeking to suppress whatever was found in the car, and apparently you think Mr. Adams gave some statement or statements to the police that same August 28th. Is that a fair? So I'm not saying that's factually correct. It's just what's in your motion.
It's a good summary. As far as statements, I'm not aware of any kind of formal interview or sit down and talk type thing, but there are many body cams from various angles, various officers, and people are, hey, this is what's going on here, that type of thing. I don't know if there's anything more than that, but certainly if the court were to rule on the Fourth Amendment issues, the point of detention would be the same or require Miranda. There's no Miranda.
Okay. All right. Got it. Other things that you're seeking to suppress, or it's whatever was found in the Explorer and then any statement that might be other than biograph, what's your name, that kind of thing. Or is there something more? Because again, you didn't mention anything about drugs.
Yeah, well, I have a weird set of reports, probably because it's a task force type of case, but it's not really clear to me where drugs were found, but they've charged them with trafficking, and there's hundreds of grams of MDMA suspected that turns out, I guess, to be tested as methamphetamine. But when the officers are making the arrest, they're saying it's on top of the car, but I don't know if that was as a result of the search or co-defendant putting it there or how it gets in that location, but it was in some bags that they opened that revealed this.
Okay. Got it. Ms. Davis, anything you want to share preliminarily before you call your first witness?
No, Your Honor.
Okay. Well, when you're ready.
State would like to call Officer Patrick Charles.
First name Patrick, Patrick, last name Charles, Charles.
Whenever you're ready.
I'm ready.
Sergeant Charles,
Yes,
is that
ma'am.
correct? Where are you employed?
City of South Fulton Police Department.
And what is your official title?
Sergeant, I'm over narcotics and gangs.
How long have you been employed with the South Fulton Police Department?
A little over 5 years now.
How long have you been involved with narcotics and gangs?
A little over 3 years.
Are you post-certified?
Yes, ma'am.
Were you post-certified on August 28th, 2024?
Yes, ma'am.
What was your title on that date?
Detective.
And you said you work for or work with the narcotics and gangs unit. What is the purpose of that unit?
The purpose of the narcotics and gang unit is to pretty much dismantle any drug operations going on in the city of South Fulton. We also work with outside agencies, whether it be local or federal. We investigate, we conduct investigations, and upon our findings of the investigation, then we would execute a search warrant and make any necessary arrests.
And on August 28th, 2024, what was the South Fulton Narcotics and Gangs Unit doing on that date?
On that day, we were conducting a buy bus operation where we met with a CI that was given by the FBI in relation to a narcotic transaction that was supposed to happen at the Wing Depot. So on that day, we partnered with the outside agencies. We had plainclothes officers and detectives in the area of the Wing Depot watching what happened prior to the transaction, and also after. Upon the completion of the surveillance portion of it, takedown units were called in to arrest any parties involved and acquire any evidence.
And where did this occur? What was the location?
I don't remember the numerics. It was at the Wing Depot located in Roosevelt. That's right on the intersection of Roosevelt Highway and Buffington Road.
And do you recall what city that's in?
It's in the city of South Fulton.
And
And you said it's Roosevelt Highway in Buffington? It's at that intersection?
Yes, sir.
is that in Fulton County?
Yes, ma'am.
You indicated that there were some officers there in plain clothes,
Correct.
and they were, I guess, undercover officers.
Correct. They were in unmarked, I guess, regular vehicles. Some of them were South Fulton, and also some of them were FBI.
And this was in response to a narcotics transaction that you said was going to occur at that location?
Yes, ma'am.
And do you recall what that narcotics transaction was going to be?
Yes, ma'am. Per the CI that's provided.
And hearsay.
Judge, this is a motion to suppress hearsay is admissible in these proceedings.
Mr. Tevis?
No, Judge, this is an evidentiary hearing.
Right.
You cannot testify about what somebody else saw on this date.
You can talk about what someone saw.
Now he's about to say what they told him, based on what the CI told me was his sentence.
Right. So, well, two things. First, hearsay is not okay in this setting. Two, you can certainly talk about steps you took based on things you learned, just not the verbatim. He told me, watch out for a blue car. You could just say, based on what I learned, we were looking out for a blue car. We're just not getting verbatim into what people said.
Okay.
Okay?
Fair enough.
Thanks.
Based on the information that was given by the FBI CI, the transaction was to purchase.
Hearsay. Same objection.
Judge, I'd ask for him to give an opportunity to rephrase what he is trying to say.
Okay.
Without saying what the CI told you, what you
Okay,
learned,
so-
or what you gained.
Okay. So the purpose of the operation was to observe a transaction for MDMA, for suspected methamphetamines. The purchase was to happen between Mr. Adams, the CI, and another party, Mr. Terry, at the Wing Depot.
Tell me, just so I better understand, that's three parties.
Correct.
So the CI was going to be buying from one and selling to another, or the CI was expecting to get the drugs from the two together?
Correct. So Mr. Terry was the middleman. So he would organize he would facilitate the deal with Mr. Adams, and in return, provide the drugs to the CI.
So the CI was interacting primarily with Mr. Terry?
Yes.
Okay. All right.
Sergeant Charles, were you present that day?
I was.
And were you on the lookout for any particular vehicles?
Yes, we were on the lookout for Mr. Adams' silver Ford Explorer.
Had you or your team observed that Ford Explorer before?
Yes.
Were you also familiar with Mr. Terry's vehicle?
Yes.
On that date, I guess, can you talk about who arrived first at the Wing Depot and things that you observed from the first arrival?
Okay. On that day, I observed the CI arrive first, and then Mr. Terry arrived as a passenger in a white Corolla. And then after that, Mr. Adams arrived in his silver Ford Explorer.
Did Mr. Terry and the CI have any interaction before Mr. Adams arrived?
Yes.
What was that interaction?
That interaction was a conversation as far as he was asking for.
Objection renewed. This is the hearsay. CI was a part of the conversation.
Was, why couldn't Sergeant Charles relay anything that Terry said as a co-conspirator? And why isn't the CI a co-conspirator?
We have another motion, as Your Honor is aware, to find out who the CI is.
Okay, but tell me why you think, were you able to hear what Mr. Terry was saying because of equipment on the CI, or someone was telling you what Mr. Terry was saying?
Someone was telling me because the CI had, I guess, a listening device.
Okay.
I was being relayed the information.
Oh, but by law enforcement?
Yes.
Okay, so whatever Terry was saying, someone on your team, I'm gonna call it your team, could hear that?
Yes, sir.
You just weren't the guy with the headset that was connected to hear whatever the CI could perceive?
Correct.
Okay. Concern?
2 layers of hearsay now, Judge.
Why is what Mr. Terry says hearsay?
Well, one, I would say that the best evidence of that would be if there's a recording of that we would want it. 2.
But
if
hearsay and best evidence are two different things.
2, if they're going to say that he's a co-conspirator, the first step is to establish that there is a conspiracy, not just a buyer-seller relationship, something like that. That hasn't happened. And then 3, we now have somebody telling us what someone else told them that they heard on a recording of somebody who we don't have any information about Terry. I know he's charged in the same indictment, but they're not part of this hearing. I've never seen anything that they're involved in a conspiracy.
Okay.
As Your Honor knows, I don't know off the top of my head, but oftentimes I'm raising this issue in federal court that a buyer-seller relationship is not a conspiracy.
I will let you answer questions about what Mr. Terry said, as long as you're confirming, Ms. Davis, that that's coming through actual, we heard it because of devices, as opposed to the CI come back to the car and the CI said, Terry told me it's all about Mr. Adams. And I think right now we're in a setting, based on your testimony, that you are being apprised of what Mr. Terry said by a colleague, and you can certainly react on, and you're not taking it for the truth of the matter asserted, what a colleague tells you during an active investigation, because your colleague heard it directly because of the equipment the CI had. Is that a fair summary?
Yes, sir.
When we're in that realm, then you've preserved your objection. But if we shift to, well, then I was debriefing the CI and he said X, Y, Z, that's different. And we should pause and see if there's a different basis for that to happen.
Understood. Okay. So going back to Mr. Terry arrives and the CI is present, what is observed by the officers who are already there?
Okay, just so I'm clear, you're talking about the CI and Mr. Terry, correct? Okay. There's a
I'll wait till he answers it. But the question about what other officers saw as inviting a repeated objection to hearsay. If he saw something, I have no objection to that.
Hold on 1 second. So I'm going to revise my ruling. I'm looking at Mason. I haven't had a suppression hearing in a minute. I'm looking at Mason versus State, 353 Georgia Appeal 404, a 2020 case. And it stands for the proposition, I'm actually quoting directly, a trial court is permitted to consider hearsay evidence at a hearing on a motion to suppress. Full stop. It's not if the moon is up or if they heard it through a device on a CI. And they're quoting an earlier case than that. And Mason has actually been cited favorably for that proposition. So you threw me with the sincerity and fervor of your objection, Mr. Tevis, but I'm going to look at one more thing here. But if that doesn't change what Mason stands for, I'll give you a chance to cite something if you want to, which I'll take a look at. But otherwise, I'm going to let Ms. Davis move forward and allow her to ask questions like, and what did that person say? And what did this person say?
What
But
was the citation, Judge? I got the name and the year.
yep, I'm gonna give it to you again. Just let my internet move slowly here.
Mr. Tevis, can you put that microphone in front of you, please?
Can you hear me?
I can hear you.
Thanks.
Gosh, you'd think we're on like some dial-up connection here. Oh, that's helpful. 10, 11. All right. So the case is Mason versus State, 353 Georgia Appeal 404, a 2020 case authored by Judge Rickman, Court of Appeals. And that line I read is a direct quote from a predecessor case. These are all post 2013 Code of Evidence revisions. So Mason is enough. But Mason quotes Burks, Burkes versus State, 347 Georgia Appeals 790, a 2018 case. A trial court is permitted to consider hearsay evidence at a hearing on a motion to suppress, because I'm making a threshold finding about whether evidence is it. I'm now editorializing, but to me, it's sort of like a 103, 104, whatever those rules are. Where I'm assessing the admissibility of evidence at a future hearing. Certainly at a trial, it's a different ball of wax. So I appreciate your patience, Sergeant Charles. We probably should have ironed this out in advance. But over defense objection, you can ask the questions you were asking.
Thank you, Judge. We're going back to August 28th.
Okay.
The CI arrives, Mr. Terry arrives as well.
Mhm.
What do you hear, see, and observe from the CI and Mr. Terry's interaction?
The conversation was in relation to waiting for Mr. Adams' arrival. Mr. Terry did not have the MDMA in hand, so he was waiting for Mr. Adams to bring it, as well as some switches that were supposed to be sold as well. Although the switches were never provided, it was just the MDMA once Mr. Adams was to arrive.
Switch meaning something that makes a gun fully automatic, or is that a drug term?
That is correct. A switch to make a gun automatic. But that portion was never followed through on. It was only the drugs.
So the CI had been tasked by his or her handler to try to buy MDMA and switches,
Correct.
but no switches were found on the 28th.
No, sir.
Okay.
Judge?
Yes, sir.
Could you have like a 5-minute recess so I can read this other case? Because Mason, in reading that relevant part, it's talking about motion to suppress based on an attack of a warrant in a DUI case. And in that, the hearsay was contained in the warrant. So the court says, hey, the warrant, even though he didn't have the name of this citizen, does establish probable cause. And so the court could consider that. I don't know that this stands for the proposition that at this hearing, we're not here for probable cause necessarily.
Well, it's of
That would be
course
Part of.
like the two big capitalized words in your motion.
Sure, but not.
Did they have probable cause to swarm your client's car, detain him, and search it?
No, that is, I mean, with regard to the search, that is absolutely the case.
Ah.
But with regard to the purpose of this hearsay and what this officer, I guess the problem I have is I would have probably should have done the CI motion out of turn, because now we're going to get into questions of like reliability versus tipsters and all that other stuff as well. But
the answer to your question is yes, but let me just push back right now. Let's say that instead of this hearing that we're having, Sergeant had sworn out a warrant and in it wrote all these things about the CI and Terry were talking, and Terry said, I don't have the dope, that comes from Adams. Adams will be here soon. He's bringing the drugs and the switches. That's all okay in an affidavit. And yes, it's hearsay. Sergeant didn't hear either of these people have that conversation, but we consider that all the time. And it's something that we weigh in whether it reaches probable cause or not. It's part of the discretion that we're supposed to exercise. And am I not exercising? Are we not doing the same exercise here? But it's instead of the sergeant having put it all in an affidavit and presenting it to a neutral and detached magistrate, there was no warrant, and we'll see why there wasn't a warrant. But we're still working through, was there probable cause? And in reaching that conclusion, I believe I'm authorized to consider hearsay. But why don't you take a look at that case? And I'm going to look at Burke's as well.
my response to that would simply be, with respect to a warrant, in that case, we would at least be confined to what the magistrate was told in the four corners of what was in that warrant. Here now, instead of what was known at the time, we're off the rails of anything that comes out of his mouth, true or not. I don't know, and I'm not implying it wouldn't be true, but I don't know the source of any of this. We have mystery people who are listening to a mystery device on a mystery informant. I don't know what the bounds of this are or what the court is or isn't considering. In a warrant, I can say, here's what the court was considering. If I can establish that some of that's not factual, we can have a Franks hearing about it. But here, it's just everything on the fly is whatever somebody else said. I can't cross them. There's no way for me to even, I guess, I'll leave it up to your honor, is going to have, when I am overruled on this objection, to make these credibility determinations that I don't even know who these second and third layers are, that are coming into this. So I guess that's the difference, I would say, between, at least in an affidavit, we are confined to what was told to the court to establish probable cause. This is an after the fact instead of a before the fact.
Well, the affidavit is after the fact as well. I mean, they're writing about something after it happened to get the search. But let's assume, I'm making this up, that Sergeant Charles said it was Detective Jones who was listening into the call. So Detective Jones told me that the CI and Terry talked about how Adams was bringing the drugs. That could be written in an affidavit. It could be testified to here. You have the added advantage now, instead of a static affidavit, to say, well, how long had you worked with Detective Jones? How long? I mean, you can explore that a little bit, but it's not your turn to ask questions yet. You'll be able to establish what you can by asking this witness questions. And I think we're just painting orally rather than in a written way a landscape that either provides probable cause for the stop and the search, or it doesn't. But why don't you read the cases? I will as well. And we'll just take a 3-minute break. You good?
Yes, sir.
Okay.
I thought you said it was admissible. Pretty sure it is.
Yes, ma'am. We let pretrial go a while ago.
See you tomorrow.
Yes, ma'am.
And you gotta go to the back. Turn the wires. That's what this way.
So I'm not going to have us spin wheels a whole lot longer. Mason relies on Burke's, and in Burke's, the court found that it was not error for the trial court to rely on hearsay during the suppression hearing. And more importantly, the Burke's opinion is what points us back to 24-1-2C, which says when considering preliminary issues of admissibility of facts other than privilege, the rules of evidence do not apply. And it references us then to 24-1-104, when a court's determining the admissibility of a fact for a proceeding like a trial, the rules of evidence other than privilege don't apply. And that's where we are. You're seeking to exclude certain evidence. The state wants to admit it. And I appreciate that even if certain things are found not to be excludable because of a Fourth Amendment violation or lack thereof, they still might not be relevant. There'd be other hurdles to clear. But I think we're very much operating in that space where I'm deciding whether something can be considered as evidence or not. And with Burks and Mason, I feel like I'm on all fours to be letting Sergeant Charles talk about what he heard other people say for that very, very narrow question of, was there a probable cause to do what they supposedly did? Was it the afternoon? What time of day was it?
It was early afternoon.
Okay, daylight hours on August 28th of last year. So that may upend your world a little bit, but unless you found cases that Burks and Mason aren't reversed, there's no red flag next to them, but that distinguish them in some way, or you want to distinguish them in some way. Again, Burks, the challenge was to the trial court finding a search was lawful when at the suppression hearing, the court considered hearsay, and the Burks court goes on to say, and this is what's quoted verbatim in Mason, a trial court is permitted to consider hearsay evidence at a hearing on a motion to suppress. That's where we are. We're not on a different type of hearing, and we're in Georgia. And so I'm going to rely on 24-1-2C, as well as 24-1-104 in the twin towers of Mason and Burks to say Ms. Davis can press on. But before she does that, anything you want to get on the record, Mr. Tevis?
Arrived at the same statutes. I think Burks is distinguishable because the hearsay there was the guy has a Fourth Amendment waiver, which is in and of itself another methodology to get evidence in. And at least then you can say, here's the probation officer, we know who this person was. You can have at least some notice as to who that person is. You can cross them. You can say, I get to confront that person at trial about whether this was admissible or not. I don't have to defend any of this because everyone besides the officer in the chair is unknown. So I think there's a little bit of distinguishing characteristic there. And I understand the court's ruling. I've arrived at 24-1-102 and 104, which says determining the admissibility of the evidence. I presume that means with regard to constitutional gatekeeping. So I'll just preserve the objection if I can have that, but.
You certainly can. And I think there's an additional, I don't think remedy is the right word. I think there's an additional tool that's available for you. You may on cross-examination of Sergeant Charles learn Detective McGillicuddy is who I really need to have testify. And you can present evidence as well. You are saying, I don't know any of these people. My guess is in the reports, it does name some other people. You may not be able to, maybe not, but either way, here's a live witness and you can get some names. And when we're done, you could say, time out. Please don't do an order yet. The evidence is not closed. The state may have rested, but we're going to be back in a couple weeks and I will have subpoenaed Detective so-and-so. So I can have that person come in and explain a little bit more. So we're getting it maybe not secondhand.
I think we'll need some two letters for that. But okay.
We'll see. I don't even know how that works in the current situation, but
I suspect they get largely ignored.
no comment. Ms. Davis, Sergeant Charles, you've been very patient. What I know is that the CI and Mr. Terry were talking, and Mr. Terry had said, we got to wait on Mr. Adams. He's the guy bringing the MDMA and the switches.
Correct. Thank
So
you.
wherever you want to go from there.
Okay. Did Mr. Adams show up?
Yes.
And I guess in what vehicle did Mr. Adams arrive in?
He arrived in his Ford Explorer, silver in color,
And where did he park?
to the right side of everyone else's vehicles.
So he parked near them.
Yeah, no, nearby, yeah.
Oh.
The CI had the CI's own vehicle.
Yes.
And Was Mr. Adams the only person in his vehicle?
No, I believe his daughter was in the back seat. Mhm.
And then what happened next after Mr. Adams parked his vehicle?
Once he parked his vehicle, Mr. Terry walked over empty-handed to Mr. Adams' vehicle, got into the front passenger seat, closed the door. A short moment later, Mr. Terry exited with the bag and returned back to the white Corolla, placed it on top of the vehicle. It was at that time we received the notification to move in for all the takedown units to converge on the operation. All parties were detained, and the same bag that was seen in Mr. Terry's hand when he exited Mr. Adams' vehicle was the bag that had the MDMA in it.
And that bag was placed on top of the vehicle that Mr. Terry was riding in, the Corolla.
Correct. Yes, ma'am.
And I believe the GBI did you submit those drugs for testing?
I did.
And I believe the GBI confirmed that was methamphetamine,
I'm not 100%.
but it was not inside anyone's vehicle.
No.
Before this, I guess, sting or operation, had you observed Mr. Adams previously?
Yes.
Can you tell us about that interaction, the
Yes.
observation?
There was another previous time prior to where the CI also went through Mr. Terry to get in contact with Mr. Adams, where in this instance, the CI met with Mr. Adams directly in his Silver Ford Explorer. There was a conversation in regards to how much the pills would go for, the quantity and availability of such would be able to be given to the CI whenever he was ready. Upon the exiting of the CI meeting detective at another location, he was able to provide the MDMA and the cocaine that he received from Mr. Adams.
I need you to unpackage that for me a little bit.
Sure.
So CI reaches out to Mr. Terry. Hey, I want to talk with Mr. Adams. Mr. Terry makes that happen. CI is in the Explorer with Mr. Adams. And I thought you said they were talking pricing. And I make the numbers up. You can get 100 pills for $10.
Correct.
But then you said suddenly the CI, you didn't say suddenly, but you said the CI then said, here's the cocaine that I got from Mr. Adams. Did they make a direct purchase or was that through Terry?
So the purpose of the meeting was to purchase MDMA and cocaine. On that day, the contact was made between Mr. Adams and the CI, where he exchanged the currency, the funds for the MDMA and the cocaine. So then the CI met detectives at a predisposed location to hand over the cocaine and MDMA.
Okay, so the meeting that Mr. Terry helped arrange between the CI and Mr. Adams in Mr. Adams's Explorer was one to talk about pricing, but there was an actual transaction that happened as well.
Correct. Yes.
And the CI returned to his or her handler. Here's what I bought from Mr. Adams and handed
Correct.
over the drugs.
Yes,
Okay.
sir.
And it was cocaine and MDMA that
Correct.
the CI purchased.
Yes.
Okay.
And in that interaction, was it similar to this one, whereas there were plainclothes officers there observing the interaction, or can you just describe how the officers were stationed?
That's correct. The interaction was observed by plainclothes officers in unmarked vehicles. There also was a listening device on the CI, and he met with more undercover officers after the meeting as well,
And that was prearranged.
prearranged
Was it at Wingstop?
at the Wing Depot.
Wing Depot? Is that the same place?
Yes.
Okay. The takedown was on August 28th of last year. How many days, weeks, months before was this direct purchase that CI made from Adams?
I can look in my notes to give you one moment, Your Honor.
And I also have your report, if that would refresh your recollection.
Yeah, I think I just need to get the month. Myself, last.
I don't want to approach this report.
Okay. That's great. Thank you.
It was early on in the month, Your Honor.
Same month though, August of last year?
Yes.
Okay. All right. Thank you, Ms. Davis. Go on.
Okay. And do you see Mr. Adams in court with us today?
I do.
Can you describe what he is wearing?
Yes, he's wearing a orange, red, and yellow shirt sitting to the left of his attorney.
Judge will ask that the record reflect that Sergeant Charles has identified the defendant, Mr. Adams, as the person who was involved on this date in question.
He has.
After the officers initiated the takedown, based on what you observed, did you all detain people present on site?
Yes, ma'am.
Who was detained?
On that day, the subjects that were detained were the occupants of the Toyota Corolla, which was Mr. Kyle Dixon and Austin Malone. From the Ford Explorer, it was Julian Terry, Mr. Wycliffe Adams, and Sarah Adams, which is Mr. Adams' daughter. And then after that, the employee of the Wing Depot, Robert Betts, was also detained.
And did you perform a search of the individuals that were detained?
Yes.
With an officer?
Yes.
For you, did you locate anything on Mr. Adams' person?
I was not the specific officer who searched Mr. Adams. I had searched Mr. Terry. I believe that there was a U.S. currency that was taken off of Mr. Adams' person.
Correct. What was the amount of currency that Mr. Adams had on his person?
$10,564 in cash.
Okay. What was recovered from Mr. Adams' vehicle?
The vehicle was a Glock 33 Gen 4 9mm was recovered from inside of Mr. Adams' vehicle.
Did Mr. Adams speak or say anything to you in regards to this case?
To me directly, no.
Do you know if he spoke with any other officers?
I'm not sure.
Would it be anywhere in were you the lead?
I was.
Okay. What I'm trying to distinguish today is whether Mr. Adams might have said something offhand, like you guys got the wrong guy, or what are you doing with my daughter? Something different from they sat him down at a table and the camera was running and they read him his rights and he gave a statement or he didn't. Anything like the latter happened? It would seem like that would be in your report if someone Mirandized him and took a formal statement.
Correct. It would have been. It's not that. I don't believe he was formally interviewed. Yeah. I mean, aside from the most common of the being surprised and not knowing what's going on, aside from that, I don't think anything else was pertinent.
Okay.
I just wanted to clarify really briefly that I guess I'm asking, what did Mr. Terry have in his hand when he entered Mr. Adams' vehicle?
Nothing.
And then when he exited the vehicle, what did he have?
He had that bag.
And it was later discovered what was in the bag?
The MDMA was inside the bag, and that bag was placed by Mr. Terry on top of the white Corolla.
And was it your understanding that this meetup at Wing Depot was to be in exchange for drugs for cash?
Yes, ma'am. That was the purpose of the meeting. Yes.
And you learned of that because of the CI?
Correct. And that's what led us to search Mr. Adams' vehicle, because we knew the purpose was to make a drug transaction. In addition to, we, as far as my team, Your Honor, watched Mr. Terry enter Mr. Adams' with nothing in his hand and exit with a bag, and in that same bag was where drugs were found. So it led us to believe that there's a possibility that there be additional drugs inside Mr. Adams' vehicle.
Understood. Nothing further, Judge.
Mr. Tevis?
Thank you. Good afternoon, Detective Charles,
Sergeant.
Sergeant. The previous incident you said was earlier in August. What was the date of that? It's not mentioned in your report.
Correct. Due to the safety of the CI, I don't typically put the exact date, so that way the defendant cannot directly correlate who the CI would be.
Okay, what was the date?
It's early in the month of August,
Okay, you don't know the date?
not at this current present time, but it was during the same month.
Okay, I know it's not in your report, so I'm not asking you to look in the report. I'm asking for your personal knowledge.
Right.
Do you know what date in August you had this whole previous operation set?
Earlier in the month of August.
Okay, my question is, do you know the date?
I know the date for my records. I don't have it with me right now.
Okay, so you have records that record that other incident and the date that it occurred?
Everything is documented. There's TAC plans that are written out with the exact date of the operation, correct?
Okay.
Now, whether or not I put that exact date in my report is something else. But
Okay.
yes,
Have you provided that to the state?
provided what?
That report to the district attorney's office?
The report that's provided was what I provided. What's
Right, but it sounds like you've got
like a TAC.
other paperwork, the tactical details of how that day is going to go, so everyone is safe and there's surveillance. Have you provided that to the state?
No, but I can.
I just want to know if you had or not.
Yes, sir.
We'll work through what you got to do later.
Yeah.
The operation was focused on this individual, Julian Terry, and not Mr. Adams. Isn't that correct?
He was the initial target, correct?
Okay. And I believe, was he the target of your operation or of the FBI operation?
This is information I received from the FBI. It just happened that the location of the Wing Depot was in the city of South Fulton, so they partnered with us to assist them with the case.
Okay. And so do you have any idea how the FBI knew to be on the lookout for Julian Terry or that he was involved in drug trafficking?
No, sir.
Okay. You were just told that he was the subject spearheading the operation.
Correct.
Okay. And in fact, I want to clarify, I think this went to one of Judge McBurney's questions. The CI was communicating with Terry not to get to Mr. Adams, but he was setting it up with Terry, and then you observed Mr. Adams arrive instead of Mr. Terry.
I'm sorry, repeat that?
The CI
Mhm.
was in contact with the subject of the investigation or the target of the investigation, Julian Terry.
Correct.
He did not know who Cliff Adams was at first.
Correct.
Okay. And so it was only upon Mr. Adams showing up at that location after contacting Terry that the CI met Mr. Adams
Are you speaking of on the 28th?
on your earlier operation.
Yes. Mr. Terry facilitated whoever was going to provide the drugs for the CI. It was all orchestrated by Mr. Terry.
Okay. And in fact, you or somebody else in your unit or group or task force showed the CI a photograph of Mr. Adams to even identify him.
I don't know of anybody showing photos or anything.
Okay. Let me find the page on your report and I will direct you to that. 1 second.
You want prior to the operation or after the operation?
Yeah, so if I could direct you to the report that talks about during the month of August, where we don't know the date.
Yeah.
It's page 5.
Oh, yes. Mhm.
You would agree with me that the third paragraph says that the CI met with you all,
Mhm.
and during that meeting, the picture of the registered owner of the Ford Explorer was shown to the CI, and they identified him as that person.
Yes, after the operation. Yes,
Right.
that's correct.
Okay.
Meaning that's the person I just got the drugs from.
Correct.
And that operation is the one for which we don't have the date yet. That's the earlier in August,
Yes, sir.
where it was, let's talk about pricing, and the CI got some cocaine and MDMA.
Correct.
Okay.
And the result of that, the pills that you obtained on that date were not MDMA, correct?
They were suspected as a suspected opioid, synthetic cannabinoid, and the third bag was tested. They returned as a chloropromide, and that was all field testing. We still sent it off to the GBI for additional testing.
Okay. Do you know if those results are back?
I do not.
Okay.
And we also tested the cocaine that did come back as suspected cocaine.
Okay. Field tested, you mean?
Yeah.
I heard you tell the state that there was an investigation into some switches, but I haven't seen that in the report. Does that have anything to do with the takedown on this date?
Well, what I was describing was what the original arrangement was for what Mr. Adams was going to provide. So he was supposed to provide switches as well as MDMA. The switches never showed up, so we did not include that. It was just the MDMA that was provided.
And was that something that the CI requested of Mr. Terry? Can you connect me with switches?
Correct.
Okay. The CI, you said, was wearing a recording device?
Correct.
And who has those recordings?
You had to speak to the FBI.
FBI has those. Did you listen to any of that live or recorded later on?
No, sir.
But somebody was telling you what was being said.
Correct.
And they told you, this is what Mr. Adams is saying. This is what there is a recording of Mr. Adams.
Whether or not there's a recording, sir, I do not know. I don't work for the FBI. What I can tell you is during the operation, I was receiving information of what each party was saying. That's how we knew when to move in.
So at a minimum, excuse me, the wire transmitted, you just don't know if it also recorded.
Correct.
And didn't you or any other officers take down what was said in a report?
No.
Okay.
Not on my portion. Whether or not the FBI did it, I'm not sure.
Was it the FBI that was doing the recording?
Yes.
Okay.
It was their CI, their recording. Yes. We were just assisting.
On this date in early August, specifics unknown, where did the CI meet with Mr. Adams?
We met with them at the Wing Depot.
Okay. And was that inside the Wing Depot? I noticed you guys made arrests at the Wing Depot as well.
It was in the parking lot.
Okay. And what happened in that instance? The CI get in Mr. Adams' car?
Yes.
Okay. And were you or any other officers in the car?
In Mr. Adams' car?
Yes.
No.
Okay. Nobody in undercover capacity?
No.
Okay. And was the CI wearing a recording device on that incident?
Yes.
Okay. Does the audio and video record?
I do not know.
Okay.
And when we're saying recording, I want to make sure, you know, he had some transmitting device, but I thought you told me, I don't know if it recorded. The FBI would know that. And if it recorded, maybe they have recordings. You just knew people could hear live, real time, what was being discussed around the CI because of his device.
Correct. I'm not sure if it actually saved to any kind of saving device, or whether a hard drive or flash drive, whatever the case may be. I just know that we were able to hear what was going on.
Okay. And I reference it that way because I think that's what you said and I wrote it down. I understand the judges asking, you don't know. I know you don't know if it records. You just called it a recording device. That's why I said it that way.
Right.
And if it comes up again, I understand what you mean it to be. So you were not in the vehicle. There was no video that you're aware of. You couldn't see what was happening in the vehicle, but someone's relaying what they're saying. Okay.
Correct.
You don't know how those drugs were delivered, what package or container they were in, anything like that.
Yeah. So when we work with a CI, right, prior to the CI being sent to wherever the meeting location is, their person is searched and their vehicle is searched, clear of any kind of currency, any kind of illegal narcotics, of anything. So therefore, we know that CI, in essence, is clean. There's nothing there, right? And then we observe the meeting occur. After the meeting, anything that is exchanged is brought back, is the CI surveilled and trailed back to a separate location where anything that was in their vehicle is taken out. So any currency that was found, any drugs that were exchanged is then retrieved by the detectives. And then their vehicle is searched again and their person is also searched again. So therefore, we know any kind of additional items that were found after the meeting was from the meeting itself.
I understand all that. My question was, inside the car, you don't know where the drugs were taken from. Hey, he pulls it out of the center console. It was in a backpack. He had a jar. You have an idea of what it was that was delivered to you by the CI, but you don't have any visuals of what was going on in the car.
Not to my knowledge.
Okay. And that would be the same on the second date during the takedown. You saw Mr. Terry go get in the vehicle. You saw him come out with the bag, but you don't know what the exchange was inside the car.
Correct.
And the CI was or was not in the car during that exchange?
It was not.
Stayed over by the Corolla? Okay.
You need to say yes or no
Yes.
out loud so the court reporter
I
can hear.
apologize.
That's okay.
Yes.
So just to recap my understanding, correct me if any of that's wrong, but the CI arranged the meeting and the CI shows up to that location. You all are watching this happen, yes?
The CI spoke to Mr. Terry,
Mm-hmm.
who organized the meeting to meet
Yes.
with Mr. Adams.
Okay.
Okay.
You all are observing from outside in unmarked cars.
Correct.
The CI has a conversation with Mr. Terry.
Yes.
Mr. Terry, when Mr. Adams arrives, gets in Mr. Adams' car.
Correct.
And then Mr. Terry comes back to the CI and presumably hands him something that the CI puts on the car.
That's a negative. Mr. Terry placed the bag on top of the white Corolla.
Mr. Terry put it on the Corolla. Okay. One moment.
Once he exited Mr. Adams' vehicle, he went back to the Corolla.
And the CI was in the Corolla or around the
Around.
Corolla? Okay. Terry didn't get the bag all the way to the CI before you guys swooped in.
Correct.
Okay, I'd like to direct you to page 1 of what I have that's called a case supplemental report. It's a 1 paragraph.
Yes.
This is your report as well, right? You're P. Charles?
That's me.
Okay. And you would agree with me that the second to last line says, the confidential informant then proceeded to place the bag that he was given on top of a silver Corolla.
Myra, that is correct.
Okay, so Mr. Terry exited and gave the informant a bag and the informant put it on the car.
Yes, that is correct.
When was that report written?
When was that report written?
Mm-hmm.
On after the 28th.
After the 28th?
Mhm.
Okay. And when was your initial report written?
The 28th.
Okay. I'd like to direct you to page 7 of your report, which also begins the same on the 28, City of South Fulton.
Yes.
In the third paragraph there, where you're talking about what occurred, you would agree with me that the Ford Explorer is being driven by Wyncliffe Adams. That arrives, right?
Correct.
It is common practice for subjects conducting illegal activities to complete transactions in public places and also within their vehicles to avoid being seen by law enforcement or cameras, right?
That's correct.
Upon noticing this interaction, that information was relayed to uniform officers, right?
Correct.
And then you said at that time, uniform officers saturated the parking lot and placed everyone in handcuffs.
Correct.
And you would agree with me that at no time in there, other than mentioning Mr. Terry getting into the car with Mr. Adams, does it mention that there was a bag of drugs handed off or placed on top of the car?
Okay.
Is that correct?
That's correct.
That does not appear in the report from that date.
It is not.
Okay. And curiously, I have no idea, but do you see at the top there, do you know why that report would say occurred June 10th?
I do not.
Okay. But your copy says the
That's
same?
the original date that I pulled the case number.
Okay.
As a matter of fact, if you refer to page 1, it does say, under the case number on the right-hand side, it does say the date and time report was 6/10. And so that would be the original date that I pulled that case number, which would transfer to any supplements that were completed.
Okay. What do you mean when you say pulled the case number?
So when you essentially get a case number assigned for any case.
You took the case on that day?
Correct, yeah.
I got you.
Yes.
Okay. All right. And who would have had it before you?
Nobody.
Okay. So who did you take the case from, or is that the first time you input something?
That was the first time I answered something.
All right. So in both incidences, the early August date and then August 28th, the first time the CI made the exchange inside the vehicle with Mr. Adams is what you're saying.
I'm sorry, can you repeat that?
The exchange was made by the CI inside the vehicle with Mr. Adams.
Yes,
And then on the second date, it's Mr. Terry that gets in the vehicle with Mr. Adams.
correct.
Okay. But there's no video of that. The only witness you have is from the outside. You can see people getting in the vehicles, correct?
Correct.
Okay.
When it was heard on these, well, yeah, because the CI wasn't there, so yes, it was all visual from the detectives in the area.
Okay. How would the CI communicate with Mr. Terry?
I would assume by phone. I'm not sure. I don't have direct communication with the CI, so I don't know how. The FBI would know how they facilitate the meetings.
Okay, so you had no contact with the CI.
No, sir.
All right, that was all handled by the FBI.
Correct.
And do you know who the CI is?
By face.
Okay, you don't have a name, phone number, no way to reach them. Okay. Was the CI used in the transaction in April when they contacted Mr. Terry, but a female arrived? I'm looking at page 6 of your report, if that helps.
That's right. It's the same CI.
Okay, same CI. And in that case, as far as you're aware, again, the CI communicated with Mr. Terry about obtaining drugs. And instead of Mr. Adams, Miss Lynch arrived.
Correct.
Okay. And on that case, she provided multicolored pills to the CI as well.
Correct.
And those did come back testing positive as suspected methamphetamine.
For the field testing, yes.
Mm-hmm. Do you know if those were ever finally tested by GBI?
I do not.
Okay. Excuse me. In that incident, was the communication with Mr. Terry the same as in the other instances? Meaning, did somebody, the CI, just request the drugs and Mr. Terry arranged it?
Yes.
Okay. And did you or the CI or anyone else, if you know, on the task force, know who would be delivering the drugs once you placed the order with Terry?
I don't believe so.
Okay. So the order was made with Terry. Nobody communicated with Lynch. Nobody communicated with Adams.
Correct. As far as I know.
Okay. And what was the communication or the order that the CI placed on August 28th?
I'm not sure about specific numbers, but I know it was the arrangement was to provide MDMA and the switches. I'm not sure what the exact numbers were.
Okay. Do you know if the CI specifically requested MDMA, or did they say X pills or beans or whatever the case would be?
I'm not sure the exact verbiage would be, but it was suspected to be the same thing that he purchased previously, which was the MDMA pills.
And do you know if that was that communication was by text or phone call, or
But that I don't know.
don't know? Have you all analyzed any of the cell phones that were taken?
Yes, they're the ones that were acquired on that date, the 28th. They were submitted to be they had search warrants attached to them to be dumped.
Do you know if that's been done?
Some were successful, some were unsuccessful.
Have you provided those to the state? The DA?
No,
Do you know where the extractions are located now?
I would have to get in contact with my property evidence to see if it's in it.
But they be South Fulton extracts and not FBI extracts?
Correct. Well, I know they asked for the phones after the facts. I don't know if they went and had them signed out so they can do their own extracts. but the ones that we were able to extract will be in South.
You all did.
Yes.
Okay.
Do you know which of the phones were successfully extracted?
Not off the top of my head, no, sir.
Okay. And there were 5 phones collected on that date, according to page 11 of your report.
That's correct.
Okay. No other devices that you're aware of?
And there was a DVR that was also obtained from inside the wing depot.
A DVR from inside the wing depot? Does that have capture the parking lot?
I'm not sure. I didn't.
And so you guys just took the whole device, I guess.
Correct.
Okay. Was the investigation of the wing depot concurrent? It seems to me, I guess from the reports, I thought you all were maybe investigating wing depot to start with.
Well, let me refer 1 second. No, the investigation started off by investigating 7640 Cozy Lane in Fairburn, Georgia. And then throughout that portion of it, we ended up at the Wing Depot, which was the meeting place for the certain drug transactions.
What's that Cozy Lane?
I believe that was the residence of Mr. Terry.
Do you know if there were transactions made with or without a CI at that address?
I do not.
You were not part of that investigation?
I'm sorry?
You weren't part of the investigation into 7640 Cozy Lane?
I was, but I don't know if anything was done outside of the city of South Fulton. Like, I don't know if the FBI had did anything prior to speaking to us about the case.
Okay, this says that this address, Cozy Lane, is in South Fulton, is it not?
Correct.
Okay.
I mean, the FBI also has jurisdiction there as well, so
I-
I'm not sure if they had any.
I'm sorry, I thought you said that you
I
didn't
mean,
have.
as far as using my unit, as far as the city of South Fulton Police, we did not conduct anything at that address.
I thought you said it was in Fairburn.
That's what I thought.
Well, correction. It's a Fairburn address within the confines of the jurisdiction of the city of South Fulton Police Department.
You guys have authority over
Yes.
parts of Fairburn?
Parts of Fairburn, parts of Union City, parts of Atlanta, parts of, yeah.
Really? How does Fairburn feel about that? It's just what it is?
It is what it is.
Huh. Could you, in that magic part, if I was at Cozy Lane, could I be arrested by a Fairburn PD as well as South Fulton?
No,
Oh, so it's not other than the FBI,
Yeah.
which overlaps all of it. That part of Fairburn is exclusively South Fulton.
correct. If you live at the address or you call 911, city of South Fulton will be responding.
Okay.
We have
Sounds
about
good.
120 square miles, so we encompass a lot.
I mean, that's assuming, Judge, that there's some sort of effect on interstate commerce.
Right.
So back to the Wing Depot location.
Okay.
On the same incident date, you all arrested people inside of Wing Depot as well.
One subject, correct.
Okay. Was that part of this investigation?
No,
Okay.
that was done due to what was observed by the plainclothes detectives that were at that location at that time, which was when they observed Mr. Terry walk up to the window, an exchange was made. He walked back upon searching, persons and vehicles. That same cup that he was holding was found with marijuana inside of it. So it led us to believe that the Wing Depot employee gave Mr. Terry the marijuana. Then we applied for a search warrant for the Wing Depot. When it was approved, we searched the Wing Depot, which we did find packaging material, a firearm, and also additional marijuana inside the Wing Depot. So initially, no, but then based on what was seen.
And that was Robert Betts that was the person?
That is correct.
Gun, marijuana, and packaging.
And your theory is that the person in Wing Depot sold to Mr. Terry as opposed to the other way around?
Correct.
Okay, so it was some personal use quantity, or it was enough that it looked like Mr. Terry was going to be reselling it?
Oh, it was personal use quantity.
Okay.
And then the Corolla, 2022 Corolla that Kyle Dixon and Austin Malone were arrested in.
Correct.
Tell me what part that played in this transaction.
That was the car that Mr. Terry was a passenger in when he arrived at the Wing Depot.
Same Corolla that the bag was set on top of?
Yes, sir.
Were any of the drugs or firearms found in that vehicle?
There was, 1 second, please. There was a firearm, packaging material, the digital scale, the styrofoam cup that contained the marijuana. On top of the vehicle was the Wayful grocery bag, which had the MDMA pills inside of it. Yes, aside from identification items that were inside the vehicle as well.
Okay. And what vehicle did the CI arrive in?
Personal vehicle.
Okay, and that's not named in the report, the type of vehicle?
Correct.
Okay. Not a Corolla?
Not a Corolla.
And not an Explorer? Was it an SUV?
It was not.
No. And where in the area were you in law enforcement positioned to observe this?
They were in the same parking lot, on the outskirts of the parking lot, so they had visual of the front sides of all sides of the Wing Depot, especially where the CI was parked, Mr. Adam was parked, and where the vehicle where Mr. Terry was in was parked as well.
Okay, how many officers / agents were on scene?
Numerous. Can't give you a definite number.
More or less than 5?
More than 5.
More or less than 10?
As far as undercover,
Just law enforcement in general there.
law enforcement in general.
I mean, before the uniforms swarm in and get everybody,
right.
who was observing?
I would say approximately 10.
In 10 cars, 5 cars?
Some were double occupancy, some were single.
Okay. And some of them FBI?
Correct.
And how were you all communicating?
Via radio?
Radio? There's no texting or WhatsApp, chat, anything like that, Signal?
No.
Signal.
Would this radio traffic be recorded on like a CAD report?
I'm not sure. I mean, it's the city issued radios, so it's not anything personal.
Like in the vehicle?
Correct.
Okay.
We all just went to the same channel so we can communicate.
Is that a channel that you also can communicate with dispatch?
Yes.
Were any of the unmarked officers wearing body cameras? I've seen some footage. Is that all uniform?
I believe so.
Okay. What about you? Were you plainclothes or uniform?
I was in uniform.
Okay.
You said you were in uniform.
Yes, sir.
Okay.
Mhm.
Does
Were
that
you-
mean you had a body cam on that day?
I did.
Were you in a marked vehicle?
No, I was in a unmarked vehicle with police lights on.
It had lights on it?
It had lights. It just didn't have the words City of South Fulton or police on it, but it did have lights, correct?
Lights on top or lights inside?
inside and all around.
But not a bar of blue lights on top.
Correct.
Okay.
Are you aware of any conversations between the CI and Mr. Adams or the CI and Mr. Terry once you arrested all of them and put them in the van together?
I'm not aware of any.
Okay. Nobody's reported that there was a conversation there.
Not that I know of, no, sir.
But you would agree with me that there was discussion and ultimately you and the team or the FBI decided that the informant would ride to jail with them.
I would agree that there was, I would agree that an agreement was made to transport everyone who was being charged.
Okay. And that person did transport with them back to the jail.
I can't confirm or deny that, sir.
Judge, at this point, I would like to just object. I think we're kind of getting into the weeds and trying to identify in particular what the CI is, and what role, like where they were. And so because of that, I feel like the court would need to make a decision on whether the CI's identity can be revealed before we get into that line of questioning.
Okay. I'm focused more on, because I think the main thrust of what we're doing right now is the motion to suppress. And so once everyone's in custody, the search has happened, good, bad, or ugly, whatever that search was, we're after that. So why are we exploring what happened later?
I want to know if there's any statements, Judge, and just, I don't care about
By your client?
Correct.
Okay.
He's saying he's not aware of it, but in the discovery that's been turned over by the state, there is body camera of the officers having this conversation. And the conclusion was this guy's going to ride with them to the jail. So they're in the back of a van for a very long time. They're banging, saying, turn on the air. That's a long period of time for people who just got arrested to be sitting there. I just want to make sure, I mean, if the state wants to concede that no statements used at all for anything that occurred, that's fine. I don't need to go in there.
Okay.
But my questioning is specifically statements.
In other words, if the state decided, the FBI allowed it, that the CI could be a witness, or I determined the CI could be a witness, you don't want to be surprised by the CI saying, well, let me tell you what we talked about on the way over there. Adams was saying, hey, just keep your mouth closed and for $20,000 I'll get you out of jail or whatever. You'd want to know that.
Well, certainly not just want to know it, but I've heard a lot of things in this hearing of discovery I don't have.
Yeah.
And, you know, I'm sure as the court was getting onto, if these things are recorded, I'm statutorily required to get, or the state is statutorily required to provide any recordings of my client's statements, whether they were written or actually audio or video recorded.
Mm-hmm.
So if they exist, I want them.
Sure.
But it doesn't seem like anybody knows a lot about what was going on, and I'm writing down all these things that I know I don't have already.
Okay.
So I'm not into this. I want to know who the CI portion is yet. It's not really important to me at this point. I want to know, are there any statements that are going to be attributable? And if there are, I need to get them.
Yep. Okay. So do you know if while the CI was riding to jail, if he was with Mr. Adams?
He was not.
They were in separate vehicles? Okay.
You get better answers than I do, Judge.
I asked a different question.
Is that a yes, sir?
Oh,
Yeah.
I'm sorry. I saw him he nodded very nicely, but I guess he said nothing. But yes, it was a yes.
Yeah.
Thank you.
Do you know if there were Mr. Dixon and Mr. Malone, they were arrested as well? The other two occupants of the Corolla?
Yes, sir, I believe so.
Okay. And do you know if there were any interviews with them or whether they made any statements about Mr. Terry or any other parties?
I am unaware of such.
Okay. All right. Were you involved in the search of Mr. Adams' vehicle?
I'd have to go back and look at my body cam to remember, sir.
Okay. You don't remember if you searched the Ford Explorer at all?
Just with all due respect, it did happen last year.
Sure. Yeah, I get it.
Cars, a lot of houses, a lot of people.
Okay,
So I'm willing to let you know, but I would have to look at my body cam.
okay. Do you know if that was searched on scene or did you
Yes,
tow
it
it
was.
somewhere?
It was search on scene. Yes,
Okay.
sir.
All right. Okay, I think that's all I have for this portion. Thank you. Is this your phone?
Was the Explorer, Mr. Adams had been arrested and taken from the scene. I don't know how old his daughter, the person who was with him, was that person of age to drive the Explorer away?
No, I believe a family member came on scene, and I believe with his permission, she was passed off to her.
Okay, so the Explorer had no one to drive it away.
No,
Okay, and it was just taken to impound?
correct.
Ms. Davis, do you have other questions for Sergeant Charles?
No, Your Honor, I'm just ready for argument.
Judge, can I ask one follow-up on your question?
Sure.
Actually, we're family members from Mr. Adams that arrived on scene while they were being arrested, right?
There was multiple people. I'm not sure they were necessarily family members or friends. I knew there was a crowd began to form.
Okay, the mother of his child arrived. That's
Yeah.
that's on video.
Yes.
Okay, and she was not allowed to leave with the vehicle either.
No.
Okay, thank you. This chair is fun.
It's got a good sound effect. No other questions for Sergeant Charles from either side? All right, thank you, sir, for your time. Appreciate it. And if there's paper that's not yours, make sure you just leave it with Ms. Davis.
Thank you.
All right, Ms. Davis, any other witnesses?
No, Your Honor, no witnesses for the state.
Okay. Mr. Tevis, the state is resting. Do you want to leave the record open because you are going to call some witnesses, or are you?
At this point, I don't know that I'm going to have witnesses, but I am concerned that I don't know what I don't know, and I've identified a few things today that I think I'm going to need.
Sure.
So if we could hold ruling and possibly, I'll let you know once we communicate.
Mhm.
If we say, hey, we've reviewed it, I don't think it changes anything, go ahead and rule. Otherwise, there may be some dynamics here that I'm just not, I don't want to have to close evidence and then find these things out.
Okay, I had the same thought. So you'll work with Ms. Davis to see what she can get, and then you'll enlist me if the issue is that no matter how nicely she asks, the agency isn't handing it over.
Yes, thank you. But I also do think that there's going to be some things that are not in federal custody. Like Charles said, the cell phone dumps, they got extractions, things like that.
Right, right. And it could be that Ms. Davis asked Sergeant Charles, could you get X? And he's more able to get it from FBI than you or I could. But you're right. There's some things that the South Fulton has, whether it's the tactical report that would give you the date for the first supposed transaction, whatever was found on the phones. But if there were recordings that have your client's voice on them, it sounds like those would be in the FBI's custody.
And I also flagged that he mentioned that South Fulton took the Wing Depot DVR on
Mhm.
that. So just for making a list of those things.
Okay. So where we are with statements is that it doesn't seem like it seems like your motion is moot, but that's only because no one's identified statements your client made. You need to get the evidence you're looking for, and we can revisit that. But right now, I guess I don't know what I'd be suppressing or not suppressing. You watched the body cam footage, and so if your client said something on there, you didn't highlight that as I have a problem with this, because it's one thing if they say, what's your name? And he gives his name or he gives a fake name, that's coming in. It's another thing if they say, why'd you give Terry the bag? And then they're asking about the investigation, and he says whatever he says about it. I didn't give him the bag, or because he gave me $10,000 for it. I'm not hearing you say you bumped into anything like that.
I'm not aware of any of that. My concerns are a little more alleviated in that I've now been told that of the many people that were put in the van, CI is not one of them. So if there was that conversation, we get into agents of the government.
Right.
And so that's why I wanted to go into that. But if I get statements, or if I learn that there are statements, or if these recordings do exist, I may want to renew that, but I would
Okay.
agree that for now, I don't have concern about statements.
Okay, so you're clear, you're not waiving anything if there's newly discovered evidence and you think there's a basis to suppress it or exclude it, we can explore that. But it doesn't sound like either side right now has identified statements either that the state would want to use of your client or that you would want to keep out.
Right.
Okay, so then it would be more the swarming of the car. And I don't know what you don't want the gun coming in. It sounds like the main thing that was recovered from the car is a gun. And I don't know that it was illegal for your client to have a gun. I don't have the indictment in front of me.
He's charged, I think, with possession of firearm, but.
He's just started possession, not firearm by felon.
Okay. Well, either way, he has a felony gun charge tied to the.
Okay, to the gun.
Yeah.
Okay.
I mean, it's tied to if they prove that he possessed or trafficked drugs, that's possession of firearm during that felony.
Oh, I see. It's
Count two.
possession during the commission of a felony. Okay. All right. So the gun is germane. I thought in your motion, you said there were 2 cell phones seized either from your client or from his car. And there clearly are a bunch of cell phones that South Fulton tried to extract. But my recollection is that Sergeant Charles said, we found a gun in the car, and he didn't talk about phones. Does the report say phones, or those were in your client's pocket?
They combined all of them on an inventory, so there's 5 different phones. They didn't say which they recovered where, but I believe that they recovered a phone or phones from the line too.
And not from his person?
I don't believe.
I mean-
I don't know if it was on his person. I think it was he was essentially arrested at the vehicle. Get out of
Right,
the car.
right. I don't know that it changes much of analysis if it's in his pocket versus it's in the center console or whatnot, but, okay. But you think there were 2 taken from on or near your client in the car? Right.
I just don't know which ones.
Got it.
It looks like, I mean, it's just kind of I should ask the officer while I was here, but it looks like aggregated the stuff from Wing Depot. There's like one inventory of monies, drugs, firearms, vehicles, and the number of subjects. It's all combined between what was in the store and what was in the parking lot.
Okay, because you mentioned they recovered a gun in Wing Depot, all connected with the supposed marijuana sale that, as best I can tell, has nothing to do with your client. That was a Mr. Terry personal he was doing all sorts of business at the Wing Depot.
I think he was trying to sell them trafficking quantities of MDMA, and then they just gave him a cup of marijuana.
Okay. Instead of a milkshake.
It starts at that last paragraph.
Yeah, there's the 2 cell phones.
Yeah.
Yeah, don't know which ones, but it does say 2 cell phones.
Okay. Works for me. All right, then why don't we have some argument? And then if why don't we have some argument, if you want to, based on the evidence that we have, which sounds like is going to be 99% of the record. There just may be additional avenues of exploration depending on what Mr. Tevis finds in the information that is yet to come. So when you're ready, Ms. Davis.
And Judge, let me make an argument just for the suppression, I guess, of the gun and phones. And will I also have opportunity to talk about the CI portion of it, or
We'll get to CI in a minute because I don't know what we can cover today and can't. We'll certainly start that conversation, but that may require you to get something that you submit to me in camera or who knows what. So I want to talk about logistics of the CI. So let's talk about suppression first.
Understood. Okay. Because with just circling back to the CI, it's my understanding there's like a preliminary kind of test that the judge does, the court does, and then we get to the in-camera stuff if you decide that we should
Right.
go forward. Okay. Judge, I would posit that the search performed by the South Fulton Police Department was with reasonable articulable suspicion, which is required pursuant to both our Fourth Amendment in the United States Constitution and Article 1, Section 1, Paragraph 8 of the Georgia Constitution. Officers can conduct an investigatory detention of an individual if they suspect that criminal activity is afoot. And here we have an investigation that was taking place with the subject being one, Mr. Adams, and two, being Mr. Terry, where there was to occur an exchange for drugs currency. Officers undercover and uniform collectively did observe Mr. Terry enter a vehicle with nothing on his person. They did then see Mr. Terry exit that vehicle with a bag of drugs. Those drugs were tested and confirmed by the GBI to be methamphetamine. It was over 100 grams of drugs that were recovered. These drugs were not recovered from inside the vehicle. They were on top of the vehicle. So plain view, easily able to see both the drugs and recognize them to be drugs. I would argue that the officers did have enough information to detain Mr. Adams and Mr. Terry on site and reasonably search that vehicle where they located a firearm that they have attributed to Mr. Adams. They also recovered $10,000, which is consistent with a drug buy. Mr. Terry leaves with drugs. Mr. Adams has $10,000 in his pocket. And so we believe there was ample legal justification to both detain the occupants of the vehicle and search the vehicle belonging to Mr. Adams and Mr. Terry. And we believe that there hasn't been a challenge to the CI's reliability or credibility. And so we believe the information provided both by the CI, what officers plainclothes and in uniform observed to be a drug transaction was enough to detain the defendants and to search their persons and their vehicles to recover the handgun, the money, and the drugs.
All right. Thank you. Mr. Tevis.
Thanks, Judge. I think that the state's applying the wrong legal standard. Reasonable suspicion is required for a tier 2, which is, hey, we're looking for a guy that burglarized the house over there. Don't go anywhere till we sort this out. This is immediately a tier 3 full arrest because as Sergeant Charles testified, and everybody agrees that there were many agents who the word was swarmed them and guns drawn and everybody's arrested. And so you gotta have probable cause for that.
1 sec. I gotta pause you. Ms. Nelson, is there a way to extend, the Zoom call is going to end in a second because I have a civil matter. I just want to see if there's a way we can extend it.
Hopefully Fulton County doesn't have you on the free trial.
No. I just have one account. So when we have other court,
I'm not on the main account Zoom right now, Judge. You are, so you would have to just kind of look to when the podium goes off and just reconnect it.
Okay. I'll just keep tabs and maybe shoot me a text or something when you can't hear what's going on anymore.
Will do.
All right, Ms. Rivers, we'll be on the lookout and I'll stop folks as soon as we notice the podium goes away.
Okay.
Thanks. All right. So I agree. I think the standard is probable cause, certainly for the search of the car. And that's what you're trying to keep out is what was found in the car, the phones and the gun. The drugs aren't in the car. The drugs are on top of the Corolla. You're not trying to keep those out. I guess the $10,000 in your client's pocket, you're trying to keep out as well. And there, I'll work through tier 2 when it morph into tier 3. But to get in the car and search it, you need probable cause.
For sure. And I would, I think I have laid all those standards out in the motion as far as case law.
Right. The real question is, how is it not probable cause if there appears to be evidence that there was a not insignificant drug transaction going on where Guy goes into the car with nothing in his hands, comes out with something in his hands, puts it on the roof of the car, the signal is given, and boom, it's takedown time.
Sure. Well, we don't have any information about the CI, thus the second motion, or any history or pedigree about this person. We know that apparently at some unknown date, in unknown time, a date in August that we have yet to discover that is apparently top secret. They're saying that they made some purchase from Mr. Adams, but there's no arrest in that. We have no inventory. We have no anything about that other than they're saying it occurred with this unnamed person. And so I don't think that the state has established the reliability that would be required to say, when you see two people show up in a parking lot, swarm them. The CI, apparently, by this testimony, was not doing this transaction. Mr. Terry went to this other vehicle. The CI was not part of that exchange and comes back with a bag. And so if the CI's information is not reliable, if they've not been used in this capacity before, or if the officers didn't know anything other than we're setting this up and these two people are coming to meet, you've arrested them.
All right, I think we're back. Can you hear us, Ms. Rivers?
Yes, I can.
Great.
Mr. Tevis stopped at, other than we're setting this up and these two people are coming to meet, and then it went out.
Right. So, although his direct was a little bit different from that, when I went back and asked him to clarify and look at his report, and if the court is inclined to look at take judicial notice of the criminal arrest warrants, he actually said that upon noticing Terry get in the vehicle with Adams and then get out, then they all swarmed there. And the officer was also misremembered who put the drugs on top of the car. But as I put in the second section of my motion is that at that point in time, Wycliffe Adams is seized before they know what they have. So we're at not even seized. I mean, it's an arrest if you look at the factors, that again, I don't want to go through all of the case law, but the test when determining if it rises to a complete arrest is whether there are several officers present. There were.
Well, let's assume he was completely arrested.
Okay. So he's completely arrested.
Hardest case for the state is he's completely arrested, but if there's probable cause for that, then
sure,
they would certainly win if all they needed was articulable suspicion.
There's no probable cause at that point. They have swarmed and detained them, and everybody's arrested before they even look in the bag on top of the car. As he's put in his report, as he put in the warrant, as I got him to agree. Why are we armed at the moment that Terry gets in the car and gets out and goes back to his car?
Okay, but the testimony here, if I credit that, is and it's not inconsistent. It's just missing the piece of they put a bag on the car. His written report says bag on the car. It's just the CI who put it there. His oral testimony before his recollection was refreshed by you was that I thought it was Terry put the bag on the car, but bag on top of the car. They want to freeze the situation because if that's MDMA, meth, coke, whatever it is, they don't want that rolling away. They don't want it going in someone's pocket and that person runs. So they detain everyone. No one go anywhere until we figure out what it is. They look in that bag. Woo! This is not peanut butter. Now everyone's under arrest. Why did it not evolve that way?
It just didn't. It was a full arrest before they ever got to that bag. It wasn't hey, let's hold up, nobody move, we're going to check things out. We are suspecting you of this drug deal. I mean, they weren't. It was just as was written, as he testified. We see him get in, we see him get out. Everybody swarms in, and they're blocked in. They're not free to go. Everybody's arrested, and then it's let's see what we got. Aha, we have a cup, we have a bag, et cetera, et cetera.
Okay, I guess I'm not seeing. You're saying arrested, but they certainly weren't free to go. They were detained while they figure out what's in the bag. And once they figure that out, the detention turns into an arrest.
I never once heard the officer say that anybody was detained. And that's just not what plays out in any of the reports or the warrants. I mean,
Well, I mean, the warrants are taken out much later, so I'm not worried about that part, but I don't know that it's the subjective intent of the officer that controls, as opposed to, I want to be clear, I'm not pushing back on the notion that it's unreasonable for your client to think he was not free to go. I think everyone would perceive they were not free to go. But why was law enforcement not entitled to freeze that situation to figure out what's in the bag, given everything they had?
Well, again, part of this, the problem that I have is we don't have any information on the informant, which is that other motion, which, as you know, this is not the case. Had they made an arrest, saying we went and made a buy from Wincliffe Adams, based on that, let's tell a magistrate, and now we have a warrant, let's go search his house. That's a different argument. I don't need to know who the informant is there. But if this is the only person who's communicating with Terry and all this, I don't know that that person's reliable. I don't know what they're saying. I don't know what the exchange was. If you're an observer in the parking lot and you see these two people meet and one gets out of a car and goes in the other, leaves with a grocery bag, there's no probable cause there unless you know that that grocery bag contains drugs, which requires information from an informant that we don't have to be reliable, which we have no information about the pedigree of this person.
Okay.
Part one. Part two, the vehicle. They shouldn't be searching the vehicle under these circumstances. They should have a search warrant. We have this is not a vehicle exception, not on a highway. We are in a parking lot. So you secure it, you tow it, and then you search it. Or you secure it, you get the search warrant, and you come back and you search it. It's not, an incident to arrest thing. He's out of the vehicle. In fact, they're milling about, walking around, talking about it, looking in it, and then they searched this vehicle, but there was a requirement for them to get a warrant in this case. He's not driving on the side of the road, so the vehicle exception to the warrant requirement does not apply. There also is no exigency. He agreed that somebody of driving age, my client's mother of his child, arrived on scene, that she was not allowed to take the vehicle from there. That would be another option. But even if they didn't want her to take the vehicle, they could search it with a warrant. But in this case, they just didn't. They searched the vehicle. It's a warrantless search, and the state has the burden of showing that was a lawful search. In addition to, had they gone to get a warrant, I don't know that you have evidence that there would be any reason to believe that evidence of a crime is inside the vehicle, because the state's contending you took the drugs out of the vehicle and Mr. Terry has them. So what evidence do you have to further believe that there are more drugs in that vehicle?
Well, how would that be different from, I went to the house and bought drugs, I show up with no drugs, I leave with drugs. You get a search warrant for the house because there could be more in there, just like there could be more in the car. I mean, they didn't get a warrant, so we're talking about hypotheticals.
It's one of the factors that you would put in a search warrant if you went to a judge. Okay. Hey, we just made this arrest, we scheduled this buy, this person was arrested, and we suspect that there may be more in the vehicle, but you would presumably give information as to why you would suspect that. But, did the CI see more in the vehicle in the previous time where they were in the car? That's why I asked, did you take it out of a container or a backpack, or were you just handed this thing? And so I do think that there are pieces here missing. It's easy to give the state the benefit of the doubt. They have these big task force, they worked with the FBI. It all sounds, exactly as you would have it play out in a movie like The Sting or something. But in reality, when you break this down, there's no reason for them to be in that vehicle. That was an unlawful search. They could easily have gotten a warrant. The vehicle's not going anywhere. You got 10 police on the scene, at least. They're all walking around, writing the reports, talking on the body cams, discussing the informant, all that stuff. Why isn't somebody getting an electronic warrant? Here's what we know. And so I didn't hear anything about, we did an inventory search. There was none of that. We just straight up searched the car and found a firearm and 2 phones. And so that part of it, for sure, offends the Fourth Amendment's warrant requirement that in this instance, it would have been very easy to just present that to a detached magistrate over the phone or electronically, and we'd like to search the vehicle. Okay, sure. Then you tow it to the yard and you inventory it, but that's not what happened. So I think that is a closer call. I do think that obviously when they're immediately swarmed, that is an arrest and it requires probable cause, not reasonable suspicion. But beyond that, you have this break. There's just no excuse for not getting a warrant.
The $10,000 in cash, is it your understanding from the record that came from your client or from his car?
I don't know. Presumably could have asked the officer.
I just am not remembering clearly. I thought he said it was on your client, but I just was asking your recollection. The record will be whatever the record says.
Yeah, I know that there was 10,000 plus that was collected. And the report indicated it was on his person, but I didn't hear the officer testify to that. But also, he wasn't the one arresting him and didn't remember what his car was, if he'd gone in the car and all that. So, as far as a fact finding, I wouldn't want to be held to it because I don't think he actually has personal knowledge of where it was found.
Okay.
And in the context of all those arguments, I would maintain my arguments that we have some serious problems with the lack of being able to confront all the people that he's relying on. I realize the court can take that into the probable cause calculus, but running that through the filter of an unnamed informant with unknown operations is a concern.
Got it. Okay. Let's talk about the informant. So I do want you to share with me, Ms. Davis, what you think the threshold determination is that I need to make. But before that, I guess, Mr. Tevis, you should explain to me what it is you want to know. I would be surprised if your client can't tell you who the informant is, but he may only know the informant as a nickname or something. So I'm curious what it is you don't think you already have. Is it a date of birth? Is it a criminal history or what?
I have no information, and based upon representation from the state, they don't know either. And so
I'm confident the state doesn't know because it's a FBI informant, but the state didn't allegedly have a couple transactions with the CI.
Right.
And so I'm not asking you to disclose anything privileged. I just don't want us to go through an exercise to get you an answer you already have.
No. And a lot of times, and I know that some people will file these motions to put pressure because they know the state doesn't want to reveal it and they don't really care. That's not the case here. I don't care who the informant is as a person. I want the information that they have. I believe that based on these other transactions, based on the fact that Terry was the target and they were looking at Terry's home, and when they contacted Terry, a Miss Lynch came another time, I think that the informant would have exculpatory information with regard to Mr. Adams and his alleged role in this versus the role of Mr. Terry, or what is discussed during these transactions, or what is in those communications.
Exculpatory, I mean, I see how it could be exculpatory if this were some big DEA conspiracy charge, but what's charged is this transaction.
Sure.
And not more than that. So how does the CI...
I don't want to get into what our defense would ultimately be at trial. So
Okay.
I have reasons that you could, as an officer of the court, I'm telling you that there are valid reasons that we would want to search or want to have this information to present a full defense if we were to try this case.
Okay.
But also I think that because of the fact that Terry is also indicted, presumably represented, I don't know. I'm not going to be able to ask Terry about those communications or how those discussions went or what the person was looking to get or from whom. And I could get that from a either disinterested or at least not charged informant who could say, this was my role, here's my phone, here's what we did.
Yep.
And I don't have any of that information. And I don't think it's as simple as, you know, hey, we just showed up on this date and there was an exchange bust. I get it. That's not as important for an informant.
Right.
But because of the scope of this, with the Miss Lynch thing being in April, I mean, we're talking a 4-month investigation. And if this were a federal case down over in the Northern District, I would have a lot more information. Even if they didn't give the informant's identity or any of that, I would have communications, I would have logs, I would have, you know, DEA 6s and things that say, here's what we discussed with the person, but I don't have any of that.
Right. Okay. Well, I'm going to hear a little bit from Ms. Davis, but I think we're going to circle back to of course, what's at issue in this case is this one transaction and not Ms. Lynch and not April and not an address in Fairburn that's technically in South Fulton's jurisdiction. It's interesting to you, and those are moving parts, but in the end, your client's charged with being involved in procuring, supplying the little bit of drugs that were seized in this case. And the evidence appears to be they came out of a car, he drove to the scene. All this other stuff, arguably excludable, not relevant, et cetera. So we need to assess the importance and relevance of the CI for this, and not all the, you are, it sounds like you're trying to defend Mr. Adams against a larger situation than he finds himself in right here. And I don't think I assess disclosure on, oh, that would be helpful if it were a Northern District of Georgia case, because it's not. The little piece that got hived off, or it was a smaller, I don't even know the FBI moved in this circle, but it was FBI and not DEA.
FBI.
And it was, right. And it just surprises me that it was FBI. And maybe it was the switches that got the FBI excited, but then it would be ATF and not FBI. It's FBI. So whether it just ended up being smaller than they thought it would be, or they just walled this piece off, they're clearly done with Mr. Terry and Mr. Adams in terms of whatever they were looking at. And we've got the four corners of what happened on the 28th of August, 2024. And the CI's role in that is different from all these things you just described. That hurts the state in the sense of, well, what do we know about the reliability of the CI, et cetera, at least today. But I don't know that it makes that person's role as critical as you're making it sound.
Respectfully, I disagree simply because I'm not going to lay out my case before the state. If you want to have an ex parte conversation about what I proposed a defense to this might be, I think it does play a more important role.
Okay.
And also, even though this is the transaction that he's charged with, the officer testified that, hey, there was a mystery date in August where this also occurred and this was the guy that showed up, which
he testified to that here. Whether that comes in at trial or not, it's a different issue. And if the state thinks it comes in because it's inextricably intertwined or it's 404B, then all of a sudden the CI plays a bigger role, because that was according to Sergeant Charles, that was a CI Mr. Adams transaction, mano a mano. Mr. Terry, he helped bring it about, but he wasn't even there for that. And so the plot thickens in terms of who is this CI and what is this person's reliability, etc. I agree with you. That didn't hit me as coming in, or you not objecting to it coming in, if this case, which is what's alleged, is charged.
Right. Well,
so
at a minimum, in this case, this person is communicating with Terry, and then Mr. Adams shows up, and the CI is the person setting up this agreement, who is going to say that well, I guess they're not going to say, but I do think that those communications are important. Okay. I'm not going to be able to get them from Mr. Terry. I could potentially get them from the informant if they know who that is.
Okay, got it.
You want me to? I mean, you know the law, Roviero, all these things. I can go through why I think this is more than somebody who doesn't need to be revealed. But I think we've kind of had that discussion.
Why don't I hear from Ms. Davis first, and then I'll give you as the final word. And I may yet take you up on your offer of, hey, we need to talk outside the presence of the state if I'm stuck on that. What Mr. Adams is allegedly on the hook for is this event on the 28th. So we'll see. All right, Ms. Davis.
Thank you, Judge. Public policy in Georgia favors non-disclosure of the identity of informants in the interest of free flow of information about criminal activity. And in determining whether a confidential informant's identity should be revealed by the state, the court must conduct a two-step hearing, which is what counsel was referring to. And that's three parts, all three parts being required. The first part is that the confidential informant is an alleged informer witness or informer participant whose testimony appears to be material to the defense of the issue of guilt or punishment. Part B is that the testimony for the prosecution and the defense is or will be in conflict. And part 3, which I think is the most critical that stands out, which is C, is that the CI was the only available witness who could amplify or contradict the testimony of these witnesses. As we heard testimony today from Sergeant Charles, the CI was not present in the vehicle for this particular interaction, for this particular exchange of drugs for money. The only two people in that vehicle at the time was co-defendant Terry and Mr. Adams. And so for this particular instance, the CI was not present. He or she was a part of it. They were on scene, but they were inside the vehicle. The best witness would be the co-defendant, Mr. Terry. But even if the court does deem that the witness, the CI, was not the only available witness, you must also weigh the right for the state not to disclose the identity of the informant. I do believe that identifying who the confidential informant is, their location, who they are, would compromise potentially future or current investigations that are taking place with the FBI. And so we believe that the defense has not met that burden threshold to move forward with an in-camera proceeding to determine if the CI's information could be revealed. And so we'd ask that you deny the defendant's motion to reveal the CI. I don't believe that the defense has established necessary relevance, materiality, and those are all predicate requirements for disclosure.
So, how do you envision if this case goes to trial, and we've got a jury in the room, and so hearsay restrictions do apply. Mr. Tevis cannot call Mr. Terry to the stand.
Right.
You cannot call Mr. Terry to the stand. And so if you are wanting to get in information about how did all these people come together, isn't that going to come from the CI?
Potentially. I mean, I do believe there was a degree of information that was gleaned from officers in plain clothes that were physically observing and seeing what was taking place. We would be focused on the Wing Depot, and there were several plainclothes officers that were captured on video who were able to see portions of that exchange. Did they see Mr. Adams pull out the drugs and put them in the Wayfield bag? No, but they did see Mr. Terry enter Mr. Adams' vehicle empty-handed and then walk out with drugs.
Right. Well, walk out with a bag. What they saw was him walk out with a bag. And I'm trying to figure out who you could call as a witness in a trial who could provide the context that, and I'm also thinking about this in terms of establishing probable cause, that bag is full of contraband such that the swarm was justified. It was appropriate to freeze the scene, whether we call it initial detention, then they look in the bag and say, yep, that's drugs. And then everyone, it shifts to arrest. That's for me to work through in connection with the motion to suppress what was seized in the car. But if you are convincing the jury that, how do you get, it's not just a bag?
Correct. I mean, there was a undercover operation. There was an investigation. The Wing Depot did appear to be a kind of hot spot for drug activity. I think that's well within their knowledge and expertise and their experience personally with that Wing Depot. There were several drug interactions going on, or drug transactions rather. And so I do believe that officers could testify to observing what was supposed to be a meetup, an exchange.
Right, but the way they knew it was going to be an exchange was that the CI told them, or they were listening into the interaction that the CI had with folks. And so no matter how we slice it, it's CI, hey there, give me a second. Thanks. It was the CI who is the conduit through which that information flows. And so an officer, the only way, whether it's Sergeant Charles or FBI agent, whomever, it would be because of what the CI told them or they heard the CI talking about.
I understand where you're getting at. There were also other individuals that were on scene that were also present, not in the vehicle, but were also present. Those could also be potential state witnesses to testify to what was going to take place. It was the testimony of Sergeant Charles that Mr. Terry arrived in a passenger inside the Corolla. So presumably whoever was driving him
Mhm.
would know or have some information about what was going to take place
Got
that
it.
afternoon.
Okay.
There are other witnesses, is I guess what I'm getting at.
I hear you. We're not in a scenario where the only person who could talk about what went, the officer saw what happened. Assuming what we heard here was accurate, Terry gets into Adams's car with nothing in his hands. He gets out of the car with a bag. It sounds like he probably handed it to the CI who put it on the roof of the Corolla, or Terry himself put it on the roof of the, we don't need the CI for any of that. But to explain why there were 10 officers in the vicinity, and why people thought that what was in the bag was something. I mean, there's a Wayfield Foods in that same shopping complex. And so it could well be, hey, did you get the rutabagas? Hey, Adams, you're the man. Thank you for getting me my rutabagas. And I owe you. And that's what was in the bag. But the police knew better because
That's some information.
the CI. Okay. Do you have any information as to whether the CI is, well, I won't ask that. We'll have to figure that out. Okay. Anything you want to add, Mr. Tevis?
I don't think you need to add my argument, but I would just kind of,
I think the court is picking up on the predicament that we're in. If we're kind of making an argument about you need all three pieces, and when it's convenient, we take one of them away and say disregard that for now. Then we put it back and we talk about a different one, and then we're moving those three pieces around. But you really have to have all three. For me to challenge the arrest and search, I'm saying they don't have probable cause. To rely on the probable cause is to use the CI, but we're not going to give you the CI's information. We're going to say they're reliable, but we're not going to talk about what happened. Only one instance that we've heard about. You're not allowed to know about that either. And so it really is sort of a shell game. And the defense is trying to say, look, we have concerns about the probable cause here. We have concerns about constitutional rights under the Fourth Amendment. I'm now concerned about constitutional rights under Sixth Amendment issues if I'm going to be enabled to cross-examine people about information that they have that is being withheld. Somebody has it. I realize there's state and federal play, but if anybody should lose out in a case here, it's not the constitutional rights of the defendant. It's the state is, we'll get them next time. We locked this person up. We got the contraband. We took all their stuff. And so I'm not really sure how else to get to the meat of the issue other than to say, something is not right here. We can't be deprived of all the information and then still be held to the legal standards that are being underpinned by that information, for lack of a better word.
So one of the first things you said is, I don't care who the CI is, but there are things that you think you're entitled to. I agree. And we may just need to take this step by step. If there are recordings of CI and Terry talking about what's going to go down on August 28th, I think you're entitled to those. I think Mr. Terry's lawyer is entitled to those. And if those are disclosed so you can hear more, and it's all about references to, I don't know if they would refer to him as Mr. Adams or if he had a nickname or whatever, but they keep referring to him. Bad news for you, but that might mean if the state wants to use that, then the CI would have to testify. That's my voice on the recording, and this is what we're talking about, et cetera. But it seems like consistent with your theme of, I don't really care who this person is, but X and Y and Z, certainly I'm entitled to have, is that we ought to focus on getting you X and Y and Z, and then revisit all right, well, what's needed beyond that? I mean, there'd be Giglio, was this person getting paid? Are they working off a charge, et cetera? But you could be given all that, and again,
Redacted criminal history.
right, simply know that this is asset 1234 of the Atlanta field office.
That's correct. We don't care about the name so much as, is there criminal history? Did they set this up to benefit themselves and tell these people, hey, at 3:00, bring this back? I have no idea because we're in a vacuum here.
Okay. You're not in a complete vacuum, but you certainly, it sounds like there are pieces of the puzzle that we need to figure out if they exist. And if they do exist, the state needs them because it can strengthen their case or weaken it. And then certainly you and Ms. Wood, counsel for Mr. Terry, are entitled to them. But that involves tangling with the FBI.
Right.
Okay.
Or just granting the motion to suppress. It's probably easier.
It's not about what's easy, it's about what's right. All right.
it's both, Judge.
Mr. Adams, you've sat there very quietly. Do you have any questions for me about what's going on? How old is your daughter?
This is not his daughter.
Oh.
She's on 9.
Who's here?
Oh, that's my baby girl. She's 7.
Okay. So that's like stepdaughter-ish?
No, that's my daughter.
That's your daughter?
Both of them.
Oh, baby girls, and you have an older and a younger daughter.
Yes, sir.
Okay, this daughter is 7. The one who was in the Explorer at the time is 9 now. But she's in school today?
Yes, she was.
Okay. Why is 7-year-old not in school?
Her grandma who get out the bus had an appointment. She wasn't gonna be at the house, so I had to go get out early and bring her with me. Her
Okay.
mother was at work.
Got it. So she started school today. She just
She went.
had to come early because you had to get her.
Yes.
Okay. Thanks for explaining. Ms. Davis, anything else from the state?
No, Your Honor, I would just ask that you deny defense's motion to suppress the guns and the phones, because I believe that the drugs were not a part of that motion.
Well, I don't know if the money was either, but I'm going to view it as $10K, 1 gun, a Glock 9mm, and 2 phones. But I can be as generic as need be. Whatever was seized from Mr. Adams or within the Explorer is what's on the table right now, in terms of what should be suppressed or
Right.
isn't. If we learn later it was 3 phones in the car, you don't miss out on suppressing it if I say it should be suppressed, or you don't not get to use it if it turns out it was 3 phones. The circumstances surrounding what was seized is what's at issue, not what was seized.
Yes, I would just parse the arguments in that, if it's something that is on his person, that's part of the immediate arrest without probable cause. The vehicle is that plus the added layer of should have had 1.
Okay,
And so I think the vehicle is the 2 phones and firearm.
right.
The other part would be the cash or whatever was on his person would be the first.
That's my understanding. And I'm maybe the keys to the vehicle. I mean, there was a lot that just didn't get documented. Okay, but it doesn't sound like you're contesting that it was Mr. Adams's silver in color Explorer as it was described. Okay, all right, got it. I will let you know what we're doing with the CI piece, and I will take under advisement the suppression piece. But it sounds like you want me to hold off on ruling until you have a chance to maybe get more information if it's divulgeable.
Yes, I don't know how much of a dive it's going to take on the state's part. It seems like some stuff we should be able to get, like that DVR video.
Or phone contents.
The other
Okay.
stuff, we may need to push more buttons at another level.
All right. Well, why don't I start a little email chain of us, and then we'll see where that is timeline wise.
And as far as scheduling, could we approach for like 5 seconds?
Yeah. In fact, if you'll take 3 seconds, I can handle the grand jury folks, get them on their way. Apparently, Judge Farmer is shirking his duties today. So here I am. So let me handle that, and then we'll approach. Anything more we need to get on the record? Because I can release Ms. Rivers and end this Zoom so we can get our water bill appeal up next. All right. Thank you, Ms. Rivers.
Okay, Judge, thank you.
See you tomorrow.